Welcome to the Sui Generis Show, your unique perspective on all things related to your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, civil rights and criminal defense warrior. Today in segment 1, your weekly dose of civil rights and criminal injustice system news starts with the latest developments in the Breonna Taylor case. Then we move on to a look at a member of the Boogaloo Bois who's been charged with criminal offenses relating to his shooting at a Minnesota police station. Then we conclude with the sentencing of Keith Raniere, a leader of the cult at the center of the HBO documentary, The Vow. In segment 2, as promised, we'll be exploring the relationship between your civil liberties and your civil rights. To make sure you don't miss an episode, subscribe on Apple Podcasts, YouTube, and Spotify. And you can follow us on social media. If there's a topic that you want to hear us explore, make sure you put it in the comments below and we'll add it to a future show. Look to the law office of brianjones.com and all of our social media outlets for all the information you need to know about your civil rights and the criminal injustice system. Erica, did you see in the news this week that 2 grand jurors that heard the Breonna Taylor case spoke to the media and called the police officers' actions negligent and criminal?
Wow. I mean, that's interesting, but we could probably see this coming based on the facts that we know. So what context were these statements made in?
So you'll recall from a couple weeks ago that a Kentucky judge granted those grand jurors the right to speak publicly about the case as it was presented by the Attorney General. Grand juror number 1 and grand juror number 2 spoke with CBS News and had their faces blurred. Now, it's important to note that even though the court has allowed these grand jurors to speak publicly, because of the nature and notoriety of the case, protections are still taken to protect their identities. So these statements were made to the press, but they were made with significant protections to hide the identity of the grand jurors.
Wow, that's really interesting, Brian. Were these jurors motivated to speak out because of how the Kentucky Attorney General described the grand jury process?
Yes, the AG claimed that, quote, none of the 3 officers who fired shots at Taylor's apartment was charged by the grand jury. But the grand jurors dispute that and take issue with that characterization. And this interview really digs into why they were so upset. As we previously discussed, the Kentucky Attorney General had predetermined the outcome of this grand jury session, but the jury itself did not appreciate his decision. Now, we learned later that the AG ultimately admitted he never gave the grand jury the opportunity to charge homicide against the officers that shot and killed Breonna Taylor, because in his opinion, it was not appropriate to recommend homicide charges against those officers. This is yet another example of the police protecting the police.
So what is the significance of these public statements made by the grand jurors? Is it going to make a difference in the future with this case?
Well, notably, grand juror number 1 said they couldn't provide a risk assessment and was very unhappy about that. It seemed to that person that the law enforcement never did a risk assessment and their organization leading up to the shooting was lacking. And so in that regard, grand juror 1 thought the entire raid was a negligent action. Grand juror number 2 went even further and called the officers' actions criminal in the way that they went forward with it, including the obtaining of the warrant, and found there was significant deception in the process of obtaining the warrant. I think the way that this affects future matters is that it's a warning to prosecutors and attorneys general across the nation that when you're handling police brutality cases and cases of excessive force in particular, predetermining the outcome of the grand jury session by not presenting a full set of facts and not presenting a full array of options for charges for the grand jury to issue can and will be exposed to the public. And those attorneys general and prosecutors may ultimately face consequences at the ballot box. It places pressure on them and local law enforcement to be as transparent as possible, because they now know the opinion of the public as voiced by these grand jurors want to have full transparency in these sorts of matters. most importantly, Erica, I think it really creates a record to support a second presentation of this case, either to another Kentucky grand jury by a new AG or by the federal authorities in a criminal civil rights case.
Wow, I mean that's interesting, and it'll be interesting to see what happens in the future, and how the law might change because of how these deceptions are perceived by the public.
If I recall correctly, this is the third week in a row that we have had new developments in the Breonna Taylor investigation, prosecution, and the case in general. So I would expect to see more information coming forward, and we will absolutely stay on top of this story as it affects everybody's civil rights. Nobody should have to go to bed in fear that law enforcement is going to kick in their door and shoot them dead in their bed. Now, staying with the Black Lives Movement, Erica, did you see in the news this week that a member of the far-right anti-government Boogaloo Bois was charged with opening fire and setting fire to a Minnesota police department while pretending to be a Black Lives Matter protester?
Wow, I mean, this is so disappointing to hear, because I know that the BLM movement has been taking some heat. And so maybe you could describe what the significance of this arrest is and what it'll mean to the future of the Black Lives Matter movement.
People who have fought for civil rights dating back all the way back to the 60s have been infiltrated by the political right in an attempt to seed sedition within their ranks and plant doubt as to the genuine peacefulness of their movements. This reveals the narrative surrounding the shooting and burning of the Minnesota Police Department station was entirely false. It was not Black Lives Matter activists. It was not Antifa activists who started the fire or shot at the police officers inside. In reality, it was right-wing extremists who engaged in covert operations to spread this violence. The arrest is an example of the biggest threat to public safety and order our country faces: far-right extremism and terrorism. Federal authorities from the FBI to the CIA have been sounding this alarm for decades, ever since, and most recently and significantly, after President Obama's first election. Yet law enforcement at the state level and the state law enforcement apparatus has downplayed and outright ignored the situation. They call the radical right and their activity civil disobedience, while simultaneously covering and calling Black Lives Matter protests, those who are protesting in support of civil rights, rioters and mobs.
Wow. I mean, so what is the significance of identifying the suspect?
So the suspect's name is Ivan Hunter. He was an active member of the Boogaloo Bois Facebook group. Now, this is a far-right terrorist group that advocates for violence and the use of violence with the end goal of triggering a race war, a civil war, with ultimately the goal, should they win that war, to purge non-whites from the United States of America. Boogaloo Bois is a funny name, but it's a very serious and dangerous ideology. Hunter's activity was identified on the Facebook group and seen to have encouraged yet another member in California who went on to kill 2 additional law enforcement officers. In Hunter's own words, and his associated metadata with his Facebook account were used to track his activity, identify him as the person who perpetrated these crimes, allegedly, and ultimately resulted in the charges that were filed against him.
It's so interesting to hear Facebook's name come up in this identification of the suspect. So what role does Facebook play in this situation?
I think this may be the most significant piece of information to come out and come to the public's attention, outside of the fact that we now know that right-wing extremists are the ones that are causing the violence in these protests. what we see here is an example, a very public example of Facebook's pro law enforcement position. Facebook has long been very supportive of law enforcement and very willing to turn over every little bit of data that they have collected about you to law enforcement. They have a dedicated portal for law enforcement to use to submit requests for account information and receive the authentication of documents and to use those records against an accused at trial. It's critical to note for your civil rights protection that Facebook activity is not private. Even if you are in a private group, even if you are sending private items to your friends only, even if they are direct one-on-one communications through Messenger, those interactions are not private and law enforcement can access them. No amount of account protections will prevent Facebook from pulling your data and handing it over to the police in an attempt to prosecute you. And it's not just your activity that Facebook can hand over. It's your history of likes, it's your check-ins, it's all the other metadata that's associated with your account, your photographs, your live videos, and of course your Instagram and your Facebook direct messaging history. What we see here is how favorable Facebook is to the apparatus of the government, how favorable they are to law enforcement and prosecution. And we know this because in our experience, time and time again, when Facebook holds information that can exonerate our clients, Facebook puts up a wall and says, no, you're not allowed to access that information. Facebook fights hard to prevent the criminally accused from accessing the data that can be helpful in demonstrating bias, motive of witnesses to fabricate, and all sorts of other evidence that support complete defenses and defenses that lead to an actual innocence claim of a variety of criminal accusations. So Facebook's strong law enforcement bend, combined with the massive amount of data that they collect against you, really makes it a bulwark of the right-wing government apparatus.
So a couple of things about this. I'm just wondering, I mean, first of all, should everyone go out there and delete their Facebook accounts?
Yes.
And number two, yes, they should.
Absolutely. There's so much information that's collected about you by that organization, and it has absolutely zero desire to maintain your privacy.
That's interesting. And the other thing I wanted to ask you is that, I mean, you're always hearing about cell phone companies absolutely not opening up cell phones in criminal investigations. So it seems like it's almost the opposite. It seems like Facebook is handing everything over to the police, but they won't give you anything that'll help prove your innocence. And then on the other end, on the flip side of the scale, you hear about the cell phone companies who absolutely will not let you in without the password.
There are a variety of programs that you can use on your cell phone, on your tablet, and on your computer that will maintain your privacy. End-to-end encryption is the lodestar of what you should be looking for if you want to maintain your privacy online. Using a VPN, although even a VPN can't prevent the information that's collected by Facebook. These sorts of critical privacy concerns and privacy protections should be a part of the foundation of everybody's digital life.
Wow, that's definitely interesting, and it's great advice. It's almost like last week we were talking about save all of your old computers and phones and any technology that might be able to help prove your innocence. Make sure that you are not making life more difficult for yourself by posting crazy things on your social media right now.
Yeah, that's absolutely true. Because if you have that information saved on your own devices, you can pull it out and demonstrate that you were not at the location of a murder. You don't have a history of supporting violent extremists in their attempts to overthrow the government. But if that information is contained in Facebook servers and Facebook servers alone, that information will likely never get to the jury that could grant you your freedom. Erica, last but certainly not least, did you see in the news this week, the founder of the self-improvement club and cult, NXIVM, Keith Raniere, was sentenced to 120 years on a variety of charges, including sex trafficking, that he received last summer?
Yes, I did. What are the circumstances of his sentencing?
Many in our audience may be familiar with the HBO series The Vow, a two-part documentary aimed at this club turned cult. Part one was from the victim's perspective, and it was released this year. Part two comes out in 2021 and is supposed to be from the viewpoint of the accused. Now, prosecutors allege that Raniere had led a criminal enterprise, inducing shame and guilt with the goal of controlling both his victims and his co-conspirators and grooming sexual partners for Raniere. He was convicted on charges of racketeering, human smuggling, sex trafficking, extortion, and obstruction of justice. Famously, Raniere branded his victims with his initials on their body. The sentencing hearing involved a parade of statements, very similar to that which we saw during the Larry Nassar sentencing hearing in Michigan about last year. You may recall that Larry Nassar was accused and convicted of sexually assaulting a variety of young ladies involved in USA Gymnastics. So this sentencing hearing was very similar. The circumstances of it were almost identical, with victim after victim after victim coming forward and describing their horror, their horrible experiences in great detail.
Wow. So what was Raniere's position at the sentencing hearing?
Raniere has maintained his innocence throughout this trial and through his sentencing. His attorneys walked the tightrope that is denying responsibility, but also acknowledging the suffering that complaining witnesses experienced. Now, from Raniere's perspective, he was falsely accused, and even though these witnesses have evidence of trauma, he wasn't the one that did it. He wasn't the one that caused the harm. Now, this lack of remorse is a double-edged sword, right? A defendant, in order to preserve his position and fight the conviction itself on appeal, must maintain his innocence. And by maintaining his innocence, deny any responsibility. However, at sentencing, that denial of responsibility is often called lack of real remorse and will absolutely be used against you at a sentencing hearing, as we see how Raniere suffered in this case.
Yeah, so I mean, that makes a lot of sense, but like 120 years, that's crazy. How old is he now? He's definitely not going to live long enough to see the end of his sentence. How is this possible?
I don't know exactly how old Raniere is, but if he's not a newborn infant with the longest life expectancy of any human to ever exist, he's likely to die in prison. This is a case of stacking sentences or imposing consecutive sentences. And the goal is to ensure he does in fact die in prison so that he can't get compassionate or early release and be freed from custody on parole before the end of his natural life. Now, he didn't technically receive a life sentence, and he doesn't get the benefit of appeals that go along with receiving a life sentence. But the cumulative effect and total of his sentence means that he will not live to see his natural parole eligibility. The law can, however, be changed, and every act of Congress, every change in the Congress, and every change in the presidential administration gives him yet another opportunity to ask for early release.
Wow, that's really interesting. So it sounds like we haven't heard the end of this case on the sentencing.
With as much media attention as this case has received, I think you're probably right. Remember, just last week we learned that Scott Peterson is getting another bite at the trial apple. Now, Scott Peterson was convicted many, many years ago. And remember also that Scott Peterson took the same gamble that Raniere has here and denied responsibility and continues to fight his case from prison. So in a similar vein, Raniere has taken that gamble and made the decision to keep fighting with the goal of terminating his sentence, including his conviction.
Well, I look forward to hearing all of your thoughts on this in the future, and it'll be an interesting case to follow.
Absolutely. As developments come out, make sure that you tune into our podcast because it'll absolutely be a topic that we cover. Now, speaking of topics that are cogent and relevant to our times, with days before an election, it's a great time to reflect on our rights and those that are subject to being changed by a change in administration or a change in the makeup of the Supreme Court of the United States. This is where the distinction between a civil right and a civil liberty comes into play.
Yeah, that is interesting. And you know what? I believe that a lot of people feel like those two terms are interchangeable, and they're not. So if you could tell us, what is the difference between those two terms?
Absolutely. So a civil right is a basic right to be free from unequal treatment based on protected characteristics like race, gender, disability, religion, ethnicity, in fields like employment, housing, and public facilities. Civil rights are established by state and federal legislation and interpreted through case law. A civil liberty, on the other hand, is a fundamental freedom guaranteed by the United States Constitution. They protect us from tyranny of the government, and they are most frequently outlined in the Bill of Rights, although several of our liberties are guaranteed in other constitutional amendments. Now, these can be stated explicitly, such as the right to freedom of speech, or inferred through the years by the legislature or more frequently the courts, such as the right to privacy. You'll note that the right to privacy is written nowhere in our Constitution. So our liberties include things like free speech, privacy, silence, the right to be free from unreasonable searches and seizures of our person and our property, the right to a fair trial, the right to marry, and the right to vote.
So that's great. I mean, you've given us some examples of the differences. Can you give us an easy way to tell the difference on a regular basis?
So you're diving into, with that question, a significant area, subfield, if you will, of the practice of law, in particularly constitutional law. It's incredibly complex, but the way to boil it down most simply is to look at what the right is that's affected and whose right is affected. For example, you do not have a right to receive a promotion at work, but you do have a right to not be discriminated against from your promotion, say, at work because of your race, gender, ethnicity, or religion. Now, flip that and talk about the right to get married. The right to get married is a civil liberty. So the right to get married is read into the Constitution by case law. There's no right to marry in the Constitution, but the Supreme Court has said it is a civil liberty. It is a liberty guaranteed by the Constitution. Now, the right to an interracial marriage or a same-sex marriage is a civil right.
So it seems to me that people are concerned about some of these civil rights and liberties being taken away. So there's the right to an abortion, and people are concerned about the Supreme Court and the new judges that are on there taking away the rights that have been given to us in the past. It seems like some of these civil rights and liberties could change over time. Is that true?
Absolutely. The text of our Constitution and the civil liberties that it guarantees itself doesn't change. We would have to amend the Constitution to get a change in the listed civil liberties. However, our understanding of what the text means and what it protects is constantly evolving. Our civil rights are subject to change with every new Congress or legislative session because they're primarily based on state and federal statutes that can be amended or changed by a majority vote. Likewise, as with liberties, these rights are subject to interpretation. So liberties guaranteed by the Constitution, rights guaranteed by law, by statutory law. And both are subject to interpretation by both state and federal courts in different ways, mind you, and thereby greatly depend on the perspective of the appointed judges. A really good topic to explore this in is the context of same-sex orientation. In Obergefell v. Hodges, the Supreme Court determined that the fundamental right to marry, the liberty to marry, is guaranteed to same-sex couples by both the due process and the equal protection clauses of the 14th Amendment. All states were then required to license and recognize same-sex marriages back in 2015 when this case was decided. This is an extension of a civil liberty, the right to marry, into a civil right, the right to marry who you choose. Now, just this year in 2020, the Supreme Court decided Bostock versus Clayton Clayton County, Georgia. In that case, the Supreme Court decided that an employer who fires an individual for being homosexual or being transgender fires that person for traits based on a sexual differentiation. Sex plays a necessary and undisguisable role in the distinction. It's exactly what Title VII of the United States Code forbids. Now, this was a victory for LGBTQ activists who had been fighting for decades for same employee protections for non-LGBTQ workers as for LGBTQ workers. So this is the distinction between a civil liberty, the right to marry, and a civil right, the right to hold a position that come from the same class, sexual orientation, but are protected in different ways. The constitutional right to marry, which has been read into the Constitution, versus Title VII, which protects people from being discriminated against in the workplace. Law isn't a static thing. It's dynamic. It's alive. And every day there are cases challenging these interpretations by the United States Supreme Court and all the courts that are below them. At some point, the right case could come before the United States Supreme Court again, and the interpretation could change. This is what I mean when I say that elections have consequences and voting is so important. The people we elect to the legislature literally write the laws that define our rights. And the people we elect also decide who sits as judges in the federal system, interpreting the laws and how they will be applied to us. Now, at the state level, those judges are also elected. So it's critically important to know the judges that you're voting for and know, do they support the interpretations of the laws that you feel is correct? Neither rights nor liberties are static. They're constantly ebbing and flowing. Think about the drinking age, which was at one time without any restriction, then became the age of 16, then the age of 18, and now it's 21 years old. At one point, a 15-year-old had the right to drink, and that changed due to the legislature. And then the legislature changed and they raised it, and then the legislature changed again and they raised it again. That's how your rights can be affected by the people you send to the legislature.
So how can we best protect these civil rights and liberties that we've been fighting for?
Well, you got to be informed. If it's been a while since you've taken your civics class in high school, check out one of the many informative and non-political resources that are available to refresh you on how our system of government operates. Second, exercise your rights. Get married, work, love, live, and laugh as a free and full citizen. Where you are inhibited in your rights, contact an attorney that specializes in that area, and as there are a variety of organizations and think tanks that sponsor litigation in these fields, protecting your rights and your liberties. GLAAD, the NAACP, the Mexican American Legal Defense and Education Fund, and the Anti-Defamation League are just a few that are available to help you with your defense of your rights and liberties. Last and most importantly, vote. Voting is your voice in our democratic process. Our civil rights and liberties are on the ballot every single election cycle. And the best thing you can do to protect your rights and liberties is to vote.
Wow. And I think that I'd also like to mention that, we have gone over a lot of different topics today, and, a lot of information about how to protect your rights. And one of the best way to protect your rights when they are infringed upon or questioned is by getting a great criminal defense attorney to help you. And, make sure that the outcome of your case is as positive as possible. And if you are in the vicinity of the Brian Jones law firm, please give them a call, because they are fantastic. They are at the cutting edge of the law. Brian actually teaches courses to other attorneys about the case law. And you just can't find a better place to get your rights protected. So I want to thank you so much for always keeping us up on what's going on right now in America with the criminal injustice system, Brian.
Thank you for saying that, Erica, and thank you for joining me again today. Everybody else who's out there listening all across America, I appreciate you hearing what we have to say. And to make sure that you stay informed about the latest developments in civil rights and the criminal injustice system, the cases that matter to you the most, police and government accountability, and everything else related to your constitutional and civil rights, check out the law office of brianjones.com, or find us on Facebook at facebook.com/Central Ohio Criminal Defense, and on Twitter, Instagram, and TikTok at TLOBJ. We'll be back next week with a sui generis perspective on the next big thing in civil rights and the criminal injustice system, as well as a discussion of warrantless surveillance and your digital footprint. Erica, my grandfather always told me, don't do anything I wouldn't do. And to that, to all of my friends, I add, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.